So a case challenging the NFA and its restrictions on SBRs is now in front of the Supreme Court, but once again the Trump DOJ is arguing in favor of the NFA, and they argue that the Supreme Court should deny review to this case. So let's talk about what is happening in this critical challenge. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is, of course, to subscribe to the channel. That helps the channel to grow. And also double check to make sure YouTube has not unsubscribed you. They do that a lot, especially on 2A channels. Now, I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, Attorneys for Freedom, and they're always trying to improve upon their program. So I highly recommend, if you want, in my opinion, what is the best self-defense program, check them out using the links down below. And if you use my code ARMEDSCHOLAR, you can get $50 off of your individual sign-up plan or $25 off of a family plan. Now, as I mentioned in the intro, in this video, we're going to be talking about another important NFA SBR challenge that is currently in front of the Supreme Court. This case is called U.S. v. Robinson, and it's a challenge to the NFA and its restrictions on SBRs. Now, in this petition, the plaintiff asked for the Supreme Court to find that the NFA's restrictions are unconstitutional under the Second Amendment as they apply to SBRs. Now, this case was ruled on by the 11th Circuit Court of Appeals, and in that ruling, they found that the NFA does not violate the Second Amendment. They found that the NFA's SBR restrictions are constitutional, even in light of what the Supreme Court recently said in some cases like Bruin. This has now prompted Mr. Robinson to seek Supreme Court review in this case. Now, the Trump DOJ recently filed their response to this challenge, and once again, they argue that the NFA is constitutional under the Second Amendment, that it does not violate the Second Amendment, and the Supreme Court here should deny review to the case. Now, that's not surprising because recently we saw that the Trump DOJ did the same thing in another SBR case that was in front of the Supreme Court. That case was called Rush. And in those arguments, the Trump DOJ essentially said the same thing. They argued for the Supreme Court to deny review to that case. They said that the NFA does not violate the Second Amendment. And also in that specific case, they argued that the Supreme Court should deny review to that case and potentially address similar armband questions and issues in a different case, maybe dealing with state rifle bans. But this is now the second time in just a month that the Trump DOJ has argued in favor of the NFA, and they've argued against the Second Amendment. So now the facts surrounding this case are interesting. Essentially, back in 2022, law enforcement responded to a complaint that there was a suspicious vehicle that was parked outside of a home, and I believe that was in Florida. Now, when the officers arrived, they observed that Mr. Robinson was asleep in the vehicle. He was asleep at the driver's seat, and they also saw the buttstock of a rifle next to him, and so they saw a rifle in the car. Now, officers flashed their light into the window. They woke up Mr. Robinson. They asked him to exit the vehicle, but Mr. Robinson responded by trying to drive away. Now, eventually he was stopped. They stopped the vehicle, got him out, arrested him, and then searched the vehicle. And when they were searching the vehicle, they found an SBR rifle and then also a separate upper. Mr. Robinson explained that he had bought the rifle in Tampa, Florida, and that he did not know that he needed to register that rifle. Now, a search of the National Firearms Registration and Transfer Record revealed that the rifle was not registered to Mr. Robinson. Now, this went to court, and after a bench trial, the district court found that Mr. Robinson was guilty of violating the NFA and having possession of an unregistered SBR. And later, as a response to that conviction, they sentenced him to 18 months of probation and then 6 months under house arrest. Now, Mr. Robinson then appealed that conviction up to the 11th Circuit Court of Appeals. And on appeal, he argued that this statute here and his conviction based on the NFA violates the Second Amendment and what the Supreme Court recently said in New York State Rifle and Pistol Association versus Bruin. He also argued that the NFA is an unconstitutional tax on the exercise of constitutional rights and that it exceeds Congress's powers under the 10th Amendment. However, on review, like I mentioned, the 11th Circuit rejected all of Mr. Robinson's Second Amendment claims, and they also rejected those tax arguments. And when it came to the Second Amendment arguments and that whole question about the Second Amendment, they relied heavily on the Supreme Court's Miller ruling. They stated that Miller already found that SBSs or short-barreled shotguns are dangerous and unusual weapons, and therefore they could be restricted. And here the court believed that there was no big distinction between short-barreled shotguns and short-barreled rifles, and therefore Miller still stands as valid precedent and also applies to SBRs. They stated that until the Supreme Court changes their rulings and clarifies this whole SBR issue, they are bound to have to follow Miller. Now, in rejecting the whole tax arguments, they did something a little bit different. They claimed that Bruin's ruling forecloses that type of argument, since Bruin contemplated that some objective restrictions like fees, tests, background checks, and other things like that could be permissible under the Second Amendment. Therefore, they struck down the whole tax argument, saying that this is a permissible restriction. It operates objectively. These registration and background checks and all of this are shall issue permit style systems that are potentially lawful under Bruin. Well, now that ruling is up for review in the Supreme Court, and in this petition, Mr. Robinson presents two questions. First, he asks whether federal criminal punishment of the possession of an unregistered short-barreled rifle violates the Second Amendment. Also, whether federal criminal punishment of the possession of an unregistered short-barreled rifle exceeds Congress's taxing powers under Article 1, Section 8, Clause 1 of the Constitution and the 10th Amendment. Now, originally in this case, the government waived their right to respond to the petition, but they were then ordered to have to file a response by the Supreme Court. And we just got the response from the Trump DOJ. And in the response, the Trump DOJ continues to argue that the NFA and its restrictions on SBRs does not violate the Second Amendment. Now, because of that, they asked for the Supreme Court to deny review to this case. Now, in this brief, the Trump administration argues that there is no meaningful distinction or difference between short-barreled shotguns that was addressed in the Miller case and short-barreled rifles, which are at issue in this challenge. Therefore, they argue Miller stands as a valid precedent, which is controlling in this case. They also state that Robinson's arguments that these weapons are now in common use for lawful purposes, they argue that that lacks evidence. They argue that short-barreled rifles remain not typically possessed for lawful purposes and that they are dangerous and unusual weapons that are primarily used by criminals. Now, in this argument, they state that, like its historical precursors, the provisions at issue here regulates the size of firearms, but does not prohibit any class of firearms altogether. And significantly, because SBRs combine high destructive power with easy concealability, they are especially susceptible to criminal misuse. So the Trump administration, like the anti-gun groups that we've seen before, tries to frame SBRs as these highly dangerous weapons that are primarily used by criminals and that they're used, vastly in criminal misuse. They're not used for lawful purposes, but they're an item that is picked primarily by criminals. Now, we all know that in fact is not correct, but that is the arguments that are being made here in this brief by the Trump DOJ. They then go on once again to try to hide behind the whole argument that since there is no circuit split on this issue of the NFA's constitutionality under the Second Amendment, that the Supreme Court should deny review to this case at this moment. They argue that every circuit court to consider this type of issue before and even after Bruin have upheld the NFA's short-barreled rifle and short-barreled shotgun provisions. And until there is a conflict in the lower courts, they essentially argue that the Supreme Court should punt this case and not address this issue. Now, one interesting thing in this challenge is you don't see a mention of them saying, well, deny review to this arms ban case, but take up another rifle ban case. You don't see that in this challenge. They did mention that in the Rush case. You don't see them argue that in this case. Instead, they simply say the Supreme Court should deny review to this challenge. So this is now the second NFA SBR Second Amendment challenge that has been sent to the Supreme Court. And this is also the second time in just the last month that the Trump administration has argued in favor of the NFA and claimed that it does not violate the Second Amendment. So once again, the Trump administration has argued for the Supreme Court to deny review to an NFA and SBR challenge. So that's currently what's going on in another critical NFA SBR challenge that's seeking Supreme Court review. The Trump DOJ is fighting against that, and now this is going to head to conference, and we're going to see how this plays out. So as we get more information, as it develops, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, you can check out my website, ARMEDSCHOLAR.com. Over there, we have a lot for you guys. But as always, thank you guys for watching. Don't forget to like, comment, and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.